Hi, Misha Gill, Speedwell Law. In this video, I'm going to give you 3 tips for selecting your agents. And so first, let's clarify what I mean by agents. When I'm talking about your agents, your potential fiduciaries, I'm talking about your trustees slash executors, your agents under a power of attorney, and your agents under an advanced medical directive. So we're concerned in estate planning with selecting appropriate people to serve in those roles, and so I'm going to give you some tips on how to choose those people in your life. So the first tip I would give you is a logistical tip. You need to make a decision as to whether you want people to serve in order, in succession, or all together jointly. So sometimes people approach me and they have 3 children and they say, I love and trust all my children equally, I just want all 3 of them to have responsibility. And I say, okay, that's perfectly valid and legitimate, but let's consider this scenario that plays out when you're gone. If you're appointing people to have equal co-authority, then there's the potential for people to disagree. And so you're setting people up to disagree. Now, I prefer to have have people serve as little generals and serve in succession. So that means that, okay, your kids are going to consult amongst themselves and make their opinions known, but at the end of the day, one person has the authority to make a decision and move forward without being held up by any additional objections or complaints or disagreements. So consider whether you want to name your agents in succession or jointly. The next tip I'm going to give you is that age matters. And so a lot of the time I get young couples with they just had a new baby, or maybe they have 3 babies, and they say, well, our parents did such a good job raising us and we love them so much and they're so responsible and we're so impressed with them that we want them to be our trustees, executors, etc. And that's fine. Totally get it. But you need to consider the fact that these documents that you're setting up might be applicable 10, 20, 30 years in the future. And so if you're going to name your parents in a fiduciary capacity, I would just suggest that you name someone after them who's younger. Now, if you are in the circumstance where you're later in life and your parents are gone, you have adult children. Adult children are ideal to serve as fiduciaries. They're younger than you know who they are, they're known quantities, you love and trust them. So that's ideal, but if you don't have children, maybe you're looking around and you're saying, I've got a sister and a really close friend, and who should I appoint? Well, we can consider and talk about either and both of those people and how to include them in your plan. But I would also want you to consider someone in a younger generation so that we're sure that there's going to be someone to serve after you're gone. And so it's critically important that you consider age when you're thinking about selecting your agents. Finally, my last tip for you is that judgment is more important than blood. All right, what do I mean by that? So blood is, your kin are important. And most of the time, they're going to be the people that have the best knowledge of your circumstances, the best knowledge of your wishes. They're going to know where everything is. And so in most cases, blood kin are going to be the best people to appoint as your fiduciary. However, if there is some circumstance where you don't trust their judgment, maybe they've become a known quantity where they do not have values that are in line with your values, or some circumstance has arisen that causes you to go, maybe not. Then you need to consider how important judgment is when you're considering who you're going to have serve as a fiduciary. And you really want someone who's going to know what kind of medical treatment you want, pull the plug, how to invest your money, how to raise your kids, how to distribute your assets, someone who has intimate knowledge of your affairs. And if that person is not blood, that's okay. If you trust their judgment, if you know that they're going to be the one who's going to be the best person to serve in that capacity, that's totally fine. There are additional protections we might want to talk about in the consultation about how to plan for potential fiduciary malfeasance, but it is completely okay if you don't have a family member who you trust above everyone else in the world to serve in a fiduciary capacity. It's okay to consider someone that is not blood. So that's my final tip for you. Judgment is more important than blood. Thanks for watching.